All right, let's proceed. Good morning.
Good morning. Good morning, Your Honors. Greg Batten for Leslie Bertini. Given the time constrictions today, I wasn't sure if you had any questions right off the bat and you wanted to jump right in, so I didn't know how the court wanted to proceed, given, like I said, the 7.5 minutes that I have. So,
Okay, let me just, I got to get back to my head, sorry.
take your time, Judge.
Would the proposed procedure apply equally to a body cavity search if we had to delay the intrusion for months or even years while the appeals were exhausted and the defendant would have to be held for observation or preservation of evidence pending appeals?
Meaning, what procedure specifically, Judge? Coming up here? Or?
Yes. Yeah.
Well, I guess the short answer would be yes, it would. I think it does. I think it does apply under the circumstances because.
And we would have to hold the person in custody.
No, I don't think you should have to hold them in
Well,
custody.
they have a body cavity search. The evidence could be destroyed.
Under those circumstances, it could be destroyed at that particular point in time. But I think procedurally, to get up here to address that issue, where it involves a search.
You lost and took an appeal to the U.S. Supreme Court?
I think under those circumstances, I think we still get up here, even under a Rule 15 scenario, because the way I read it, Kozlowski was a case that this court held that the Commonwealth could get up here when they filed a Rule 15 interlocutory appeal. They lost. And the rule technically says we can't get up here on appeal. We can't appeal the single justice ruling because the rule doesn't permit that. But I think the question that you asked me to address is whether or not these rules apply, and can someone who files an interlocutory appeal get up here? In my opinion, it's a trick question. Without a 211.3, which my petition was converted into, without that statute, how would anybody get up here with looking for some sort of relief given the gravity of the situation at hand? I don't know what the recourse would be if we could not file a petition. Now, I guess procedurally, the appeal of that order runs afoul of what the rule says, but I think 211.3 and the Kozlowski case, actually, because you benefited the government in that decision, I think we're allowed, or that the person should be allowed, to seek recourse up here if there's no other avenue to put that person back in the status quo. And I get the logic behind direct appeals, and we can't hear every interlocutory appeal given the fact that we've got direct appellate rights and so on and so forth. But, you know, when we're dealing with issues such as extraction of DNA or body cavity searches, I don't know how you put the person back or make that.
I can't think of a less intrusive search than a buccal swab.
Well,
I mean, there's almost no intrusive nature of it. Stick your tongue out. Thank you very much.
Right.
Have a drink of water. Thank you very much. I mean.
Got it. Here's my problem. We had the hearing. The government lost their motion initially. Yeah, you're right. Don't find any reason why we need to take the swab from Ms. Bertini. And I agreed with that. She's a joint venturer. She's a passenger in a motor vehicle, and she apparently directs her mother to park her car, the getaway motor vehicle, so the co-defendant can find the motor vehicle and take off. Okay, no problem. Not disputing any of those facts. Why do we need blood evidence? Well, we all know why, and I've addressed that in the brief, because it's to link Mr. Bertini in particular to some missing child case that happened in the 1980s. Here's my problem. The government, in what I would consider an absurd argument, comes up with, well, we've lost on the grounds that allow us to take the swab, the indictment, which satisfies, illogically, in my opinion, probable cause, plus didn't support why we could provide probable evidence of her guilt. So in the alternative, geez, Judge, let's avoid Batten coming in and citing some sort of Rule 36 issue. Let's just take it for exculpatory reasons. We needed to find that she's innocent. Well, that, to me, is the real problem in this case, because it circumvents the entire procedures and protocols for why the swab would be taken in the first place.
So if I understand correctly, you're saying,
Excuse me.
maybe in response to Justice Cordy, even if the buccal swab itself isn't incredibly intrusive, I need a chance to argue that the second prong of being able to do this post-indictment search wasn't met.
I don't agree with the first prong either, and I addressed that in the brief. I don't think supplanting grand jury's findings of probable cause to arrest, which is what this court has made very clear in tons of case law, if the grand jury finds sufficient evidence to indict, that equates to PC to arrest.
So you just disagree with our case law that says that isn't?
Well, I think that's illogical, because now we're putting in the hands of the grand jury the role and the obligation to safeguard search and seizure issues, whether or not there's probable cause that rises to a level of a search. We all know.
But that's how we do test grand jury decisions.
I don't agree with it, Judge. Frankly, I've got, the government runs the show with the grand jury. Here's the evidence. We want to get the indictment. And I think it's a short-change way of saying, okay, we can avoid our obligation to put this in front of a detached magistrate to determine whether or not there's a separate basis to search and seize. Then the second prong comes in as to whether or not this evidence is going to probably provide evidence of that person's guilt. Under these circumstances, we've avoided that now, and hey, let's force someone to turn over their DNA evidence to find her guilty, even though all along we think she is guilty, we've charged her with a crime, but we needed to exculpate her. Now, to me, that makes absolutely no sense. So how do I put her back to the status quo if, in fact, they're going to force her to provide her DNA evidence to later determine, well...
Can I ask you a question here?
Sure.
I thought the order was that the DNA is usable only for the purposes of this case.
Well, I didn't find the...
Maybe I'm wrong. Tell me if I'm wrong.
No, the judge said it. He said it's only to be applied for this case, but I don't agree that it will.
Well, is your point that once it's taken, it goes into CODIS or some
Well, no.
system like that?
The way I understand the case law is CODIS and state data bank, DNA data banks apply. And this court has held that DNA can forcibly be extracted, because now we're following a felony conviction where the statute triggers the providing of the DNA sample. We have someone with a lesser expectation of privacy at that particular point in time. We don't have that here. She's just merely been indicted. What they do with it, I don't know. I don't believe it can go into CODIS because she's not a convicted felon at that particular point in time. And CODIS is a data bank for those people who've been convicted. And that's the distinction I draw under the case law from...
Counsel, you're going to have to wrap it up. You've already exceeded your time, but I'll let you, if you would like to make a concluding statement.
Sure. Briefly, I just think the order should be reversed. I don't think Ms. Bertini should be ordered to provide the swab. I don't think being forced to provide someone's DNA evidence to find them, to exculpate them under these circumstances is justified. And the real reason, the second prong, the collateral issue behind this, to address Justice Bartford's point, is we're going to use this DNA in some way, shape, or form to go back to what some missing child case in the 1980s is. I'll rest on the balance of the brief, and I'd ask the court to reverse the order.
Thank you.
Thanks.
Good morning. May it please the Court. John Mulcahy, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. Your Honors, as the Court has already observed, the motion judge ruled, and this is at transcript pages 128 to 129, that the DNA sample from Ms. Bertini is to be used only for this case.
And how do you propose to keep it in some fashion that it cannot be used by any other ADA or any other part of the district attorney's office other than in connection with this case? Where is it going to be kept? How is it going to be kept away from everyone else?
How's it going to be kept out of the data banks?
It's not going to be put in the database, Your Honor, because the statute for the database, which is General Laws Chapter 22, General Laws Chapter 22E, Section 3, expressly says that the database is only for DNA samples from convicted persons, persons that are sentenced to 1 year or more in the state prison. So the statute only applies to people that have been convicted. In the normal course, what happens with these buccal swab samples is...
Pause right here. So can you hold it until such time as she is, and then
No, it would not be held. No, she would then have to give another DNA sample when she's been convicted. So to address the court's other question, the DNA sample would be destroyed at the termination of this case. It is only
No, go ahead.
It is only kept with the file for this case, and then it is destroyed. It's not something that the state crime lab holds on to.
And what about the profile that's developed from it? Is that similarly destroyed?
That would similarly be destroyed.
So when the state police laboratory does this, I understand what you say about the state statute and convicted felons. But is that also true of the other databases? I mean, there's no sort of, state police crime lab person automatically puts it into a national, nothing like that?
No, there's nothing like that. No, the state police crime lab does the testing pursuant to requests by the district attorney's office, and then they relay the information to us, but they do not put the information in any database.
They keep records of it themselves?
They do not keep records of it. No, they do not.
They don't keep the profile, they don't keep the sample, they return the sample, they return everything to the DA?
To the district attorney's office. The sample, once the results are given to the district attorney in terms of whether there's been a match or not, then the actual biological information is destroyed. That information is destroyed.
Destroys it, the lab destroys it?
The lab destroys it.
The lab destroys it, and they don't keep a record of what they've done?
I do not know that answer directly, Your Honor, but from my understanding, I'm sure they keep their own internal records, but they are not keeping this information to track it and use it in the future or for the district attorney's use in the future in a future prosecution.
But why wouldn't they keep it, though? I mean, what happens 10 years down, if the defendant's convicted 10 years down the road, somebody determines that there's been a problem, either at the lab or someplace like that, and that we believe that the profile that was developed, in fact, is not the profile of the defendant. We've destroyed the evidence. I mean, how can she prove her innocence 10 years from now?
Well, we would have, Your Honor, we would keep the results of that information in our own files, and the district attorney, obviously, for cases other than first-degree murders, we maintain those files for 25 years. So we would have the results in the district attorney's files, and they could be used in that case. But as it stands right now, the statute and the database and the whole concept of maintaining this information is only for persons who have been convicted.
Can I switch topics?
Sure.
With respect to Ms. Bertini, if the test is post-indictment that you have probable cause that she committed the crime, and then that you have to show that the evidence sought will probably provide evidence relevant to the question of her guilt. Okay, she's indicted. We've got the first part. With respect to the second part, I don't see what that evidence is. There's no dispute that she was not on the scene at the time, correct?
There is a dispute. She was not actually in the convenience store where...
That's what I mean. That's what I mean.
Okay, she was not in the convenience
store. Was that the
store.
motel or whatever it was?
No, actually, she was in a car on a side street.
No, later, though.
Later on.
Yes,
I'm sorry, Your Honor.
Yes, she was in the car with her mother. No, I understand that.
Okay.
So what is it going to tell you about her guilt?
Your Honor, I think there are several pieces of evidence here. First of all, she was in the motel room where the necklace, the gun, and the magazine were found. And so she exercised a certain level of control over that motel room. And so it's the Commonwealth's position that it's probable that her DNA is located on this gun, on the magazine, on the necklace.
But so what does that tell you about the crime?
That can tell us a lot of information about her role in the crime and whether or not she actually handled pieces of evidence that are part of the indictments in this case.
Post-crime? I mean, I don't...
Well, she was also, Your Honor, part of the criminal enterprise from before the robbery through the end. She told the police and this is in supplemental record pages 2 through 4. She told the police that she and her husband on the Friday before the Monday armed robbery had gone looking at several different convenience stores. As the court observed, she had the getaway car positioned. She told her mother where to put the getaway car. She also was in the hotel room with her husband where they were found after the crimes. So there are several different aspects of this crime that show that she was a classic joint venturer in this case. She participated very thoroughly in the criminal enterprise that occurred.
So what does touching the items afterwards in the motel room have to do with anything?
Well, she may have. I think it's part of the prosecution of the case in terms of the circumstantial evidence that the Commonwealth can put on that she was involved in the crimes.
Counsel, I'm sorry, but your time is up. You may make a concluding statement if you'd like.
Just Your Honors, I thank you, and the Commonwealth will rest on its brief.
Thank you.
Thank you.